the way bankruptcy works is it's a pretty cut and dry, for most cases, it's a pretty cut and dry process. Is you meet with your lawyer, you give your lawyer a bunch of information, you know, the taxes, pay stubs, bills, like what do you own, things like that. And if you're under the means test, you qualify, you don't really have a lot, the lawyer just submits the stuff to the court, and you go to a hearing with the bankruptcy trustee, and it's an easy, quick, no asset case because everything falls within the exemptions. And then if nobody objects within 90 days of the bankruptcy being filed, you get your discharge and you call it a day.
Hello, everyone. Welcome back. It's time for another episode of the Ramos Law Difference Makers podcast, where I, as your host, Dr. Jim Hoven, have a chance to just visit with really cool people doing really cool things. And today, we're going to have another chance to visit with someone who is absolutely making a difference in the lives of people who need it most, those who are going through bankruptcy. Today, my guest is Mr. Rob Cohen from Cohen and Cohen PC, and they are a firm that focuses on helping people through bankruptcy. We're going to talk about the challenges. We're going to talk about the cyclical nature of it. And I'm telling you, this is such a great person, great authority on the scene. I've been visiting prior to the start of recording, and just his story is amazing. And the fact that he loves the outdoors and fly fishes, man after my own heart, this is going to be good. So Rob, thanks so much for coming. Welcome to the show.
Well, thank you for having me.
Absolutely. We were talking before about the cyclical nature of bankruptcy. And I know that there has to be a lot of economic climates. Can you speak to some of the things that basically cause the cyclical nature? Is it politics? Is it, wage per hour things? Is it the mortgage rates, or is it a combination? What causes it?
Well, the answer is yes to your question.
The answer is yes.
That's right. No, bankruptcy it's typically seen as a lagging indicator of the economy. And so usually bankruptcies will spike after, 1 to 2 years if there's some kind of economic shock. And so, for example, in 2007, 2008, bankruptcies nationwide peaked in 2010, 2011.
Oh, and so, right after that collapse in 7-8, then it took that lag.
It takes that long. And that's because most people will hold on, and most people and businesses will hold on as long as they can. I mean, of course, there's always a segment of people that need instant relief if when they lose their job, but that's not for most people. They hold on for as long as they can. They tap into existing credit. They tap into family members. Maybe they don't lose their job. Maybe they become underemployed, and it takes 2 years for that monthly deficiency to finally add up and hit. And that's what we're seeing right now too. So we saw a great big economic shock here in 2019, obviously.
Yeah, with COVID.
2020.
2020,
right?
yeah.
2020 COVID. And we're about 2 years out now, and things are picking up. But here's what's interesting about it is that I don't have the numbers in front of me, but bankruptcy filings, the peak bankruptcy filings are 2010, 2011, and they're down 80% from the peak in 2011.
Wow.
2010, 2011 to roughly, like 6 or 7 months ago was like the lowest. And so, so they're on 80%.
That's
and now
amazing.
They're picking up. Mm-hmm.
Is there a reason for that? Is it just the natural lift, the tide of a good economy and a good environment raising all boats, or?
Yes. And this is probably for people that are a lot smarter than me that study this sort of thing. I mean, I can only just tell you what I see.
Yes.
I honestly track these numbers on my own. I kind of try to keep my finger on the pulse, but people spend a lot more time on this than I do. But, my own personal thoughts on this one are that, people, they filed in 2010, 2011. The vast majority of people only file bankruptcy once. It's, your fresh start. And they got their bankruptcy done. They've got their lives back in order. And you're right. Like, and 2012, 2013, things started getting better. They started getting better and better and better. Now, of course, we were still filing bankruptcies for people 2012, 2013 that had held on from the 2007, 2008, and they're just finally starting to catch up to them for whatever reason. Mm-hmm. And so, but honestly, once 2016 hit, the economy started really improving, and people just didn't need it anymore. And so the bankruptcy filings are way down. It's been funny. It's been interesting watching this Darwinian purge, if you will, of bankruptcy lawyers over the past 10, 15 years. The bankruptcy bar in Denver, it's really, there's not a lot of us left. Wow. And it's been super interesting because you really can't dabble in bankruptcy. You really got to do it a lot.
That makes sense. And I know that there's got to be a stigma or a personality. If someone says, man, I got to go through this, God, there's got to be a lot of emotional upheaval and turmoil. And that might keep people longer, holding on longer. Or is there, like, how would someone know when they should declare bankruptcy? Are there some guidelines that you would offer, like, if this, you should consider it, versus if this, then, hey, man, try holding on a little bit longer?
Well, okay. So emotional stigma versus when should we file bankruptcy? Those are two separate questions. So I'll address your second one first, though, because I think that's right. I think that's what you're really asking.
Yeah.
But so, most people, when they come in to see a lawyer to file for bankruptcy, they've been bankrupt for 6 months at least. Like, they just didn't want to admit it yet. And so the vast majority of the time someone comes in when they can't pay their bills anymore, when the writing is on the wall, like next month, it's going to either be their mortgage or it's going to be their credit cards. Mm-hmm. That's when most people come in.
And so, their credit's already ruined at that point,
not
as
yet,
far as
because they're not late yet.
Okay.
But they're about to be late, and they know the writing's on the wall, and they say, "What can I do?" That's when that's typically when most people come in. A lot of people will come in once they've been sued, and once they're getting garnished, and that's always. Frustrating is the wrong word, but it makes the case more difficult, because the way bankruptcy works is you usually, as an attorney who's representing someone who's filing bankruptcy, you want more time than that, because when someone comes in, their wages are already being garnished because they didn't do anything, and then you got to file the case pretty fast to stop the garnishment. But oftentimes there's a certain amount of pre-bankruptcy planning and thought that needs to go into filing a case, and you need a little bit of time to do that. And so if someone comes in too late, it's a problem for them. So I guess if you're asking when should someone come in, it's probably 6 months before they think they should. Yeah.
And at least have a consultation and say, hey, here's where I'm at. What are my choices? Because I could see also something that you mentioned was this thought of if you're getting sued. So if someone's getting sued, is bankruptcy sometimes a strategy to protect assets from a lawsuit, or is that a whole different thing?
Yes to both of those questions. So you can, take a step back, I guess. So if you do nothing, if that's the option someone chooses, they do nothing, and they can't pay their credit cards, then eventually you get sued, because it's an easy case. I mean, did you pay it? No. Do you owe it? Yes. Okay, breach of contract. Yeah. It's just law school 101.
There you go.
And so then what happens in Colorado, I mean, every state is different, but at least in Colorado, and most states like this. I think Texas, there's no garnishment, but there's qualifications to that. But most states are like this. If you get sued and you lose, then they get a judgment against you. And then the judgment is essentially a document that you give to the creditor, and you say, okay, you're allowed to go collect on them. And so then every state is going to have exemptions. And exemptions are laws that the state legislature has passed that says, okay, debtors, the people who owe the money, they're allowed to keep certain categories of property up to certain dollar amounts. And those categories and dollar amounts vary tremendously by states. Colorado's pretty generous. And so one of the things that Colorado does is Colorado says, okay, creditor, you can garnish up to 20% of up to someone's wages. And that is by far the most common way that creditors get their money. So you sue somebody, you win, you garnish their wages, you garnish their bank account, and you put a lien on their house. And that is probably 90% of the way people collect. But honestly, if 20% of your net wages are taken, that's usually, I mean, if you've already been sued, it means you can't pay them. And then all of a sudden they take 20% extra. That's it.
That's a kiss of death.
Yeah, pretty much.
And so going back to the emotional side of this, then you have to be considered some sort of an advisor at some point, not just giving them the facts of how to walk through the process. But if, like you say, most people only do it once, but I imagine your self-esteem, how you view the world, becoming jaded or feeling hopeless and helpless at that point. I mean, I can only imagine when you take away the identity that people put and the dignity with being able to take care of themselves, that when that gets stripped away, that it's got to be hard. And how do people deal with that, or what role do you play in that?
Oh, that's a tough one. So you're talking about the whole attorney and counselor at law component of things. So a lot of people, here's the thing. Most people feel really, really bad, and they feel like you just described. Sometimes there's people in there, they say, well, I don't care. It's a legal right. It's a legal remedy. It's in the Constitution, and I can file bankruptcy, and I just got to do it. They don't really care. Some people could care less about it. That is the exception and not the rule. Most people come in, people cry all the time. They feel awful. There's especially religious people as well feel even worse about it, because it's beyond just feeling bad. It's like, listen, I'm betraying my faith kind of thing. And that's actually the worst. You see religious people suffer a lot longer than they should suffer because of that. And that always bugs me. I don't like anyone to feel bad, but religious people, I don't like them to get hit even harder, right?
Yes.
And so honestly, how do I deal with that? I don't know. I just don't know how my bedside manner is. That's one of the things I've always sort of been critical of myself, is that for me, I'm not much of a hugger, right? And so, like metaphorically or actual in reality, I'm not much of a hugger. And so I tend to just tell people, look, these are the facts. This is what you can do. And then if they're really suffering or they're very upset about it, I'll say, look, I know this is your first time. I've done thousands and thousands of cases, and you're going to see what this process is like. And it's not as big of a deal as you think. I was like, and I've learned, there's nothing that I can say to take away their feeling of guilt. I can take the edge off a little bit, and I can say, listen, this is how this works. It's a process. And here's the thing too, you can always pay back your debts after bankruptcy if you want to. All bankruptcy does is prevent people from collecting on you. That's all it is. And honestly, I had one client once tell me he did that. He filed bankruptcy and he paid off all his debts later when he got a really good job again later. Great.
Yeah.
And so that's what I tell people. But yeah, I'm not much. I try to. There's a box of tissues in my conference room for a reason.
Yeah, because it's tough times.
It is. It's tough times. But I'm more effective if I say, listen, these are the facts. Don't worry about it. Here's some reading material for people who are really into it. I have this old article, like Bankruptcy in the Bible, for example. And so, you have someone who's a Christian and they come in and say, listen, I cannot do this. I say, well, listen, I'm not a pastor. I'm not an authoritative source on the Bible, but here's an article that someone wrote. Maybe it makes you feel better.
Gives you some clarity.
Yeah, people love it.
I imagine.
Yeah.
When it comes to bankruptcy, you mentioned the person that paid back the bankruptcy. Can you describe the basic types of bankruptcies? And I'm not much into this, but I know there's chapter whatever, 11 or 7 or 13 or whatever they are, and what the difference is. Is one of them designed to be end all, like, hey man, we're wiping this debt away, while another one is a restructured debt? And can you just speak to the types of bankruptcy?
Yeah, so the names can be a little bit misleading on the types of debt. So there's for individuals and businesses, there's the 3 main types of bankruptcies. So there's 7, there's 11, and then there's 13. So chapter 7, chapter 11, chapter 13. You get the name chapter because that's the chapter of the title of the U.S. Code where they're under.
Okay.
So it's like the shorthand way. So it's chapter 7, chapter 11, chapter 13. There's like chapter 9 and chapter 15. There's chapter 12 for farmers. So like 9 and 15 are for municipalities and things like that. But those are very, very rare. So it's usually 7, 11, and 13. So a chapter out of those 3, the chapter 7 is by far the most common case filed, and that's just the consumer bankruptcy, and it's called a chapter 7 liquidation. People hear that and they think, oh, liquidation, I know what that means. It means everything I own is going to be liquidated. That's not what happens, because remember I told you earlier, those states have those exemptions, right? The things you get to keep. Without going into too much detail about how the exemptions work in bankruptcy law, the bankruptcy law usually will adopt those state law exemptions. And so if everything that the person owns falls within those exemptions, then there's nothing liquidated. And so what you do is you file the bankruptcy, you see what you have, does it fit within those categories? Yes. Okay. Then the practical effect of, at least in Colorado, for sure, I think, again, I don't have the numbers on this, but anecdotally I can say at least 85 to 90% of all Chapter 7s filed, the people wipe out all of their debts. And there's exceptions of things you can't wipe out, but they wipe out all their credit cards, medical bills, evictions, like repossessions, things like that. And then they keep all their stuff. which is a super good result.
That's really generous. Yeah.
It's a very good result. Yeah. And so it's a really good result. And so, you wipe all your debts, keep all your stuff, good result. And so because it's a super good result, there's income testing you have to pass before you can qualify for a Chapter 7. Now, I don't have those numbers in front of me, and it changes every 6 months or so, but for a household size of 1, right now it's like 75 grand. I think household size of 2 is roughly 90-ish, and it goes up maybe roughly.
Meaning that you've got to show you make less than that?
Yes, that's right.
Yep.
Yeah, make less than that. And so, and then, so they means test Chapter 7 now. And so that's how you qualify. But most people can, most people can meet the means tests.
And then if someone were to be in that means testing program and then after bankruptcy get educated differently or win the lottery or get a great job, do they have to get re-means tested? Or
no.
Once you're through it, whatever happens, and you just best of luck to you?
Yeah, pretty much. I mean, there's a handful of rules that say, within a certain time frame after filing bankruptcy, if you come into a windfall of cash, so that they can take that cash and pay off your creditors. But here's the thing. I mean, anecdotally, again, the average amount of debt someone files on is anywhere from, in a normal consumer case, notwithstanding businesses and guaranteed business debts, because that's a whole nother conversation when people file because businesses go under and they personally guarantee the debts. But, $20,000 to $80,000 of debt, I would say is probably within the bell curve, for most bankruptcies. If someone comes into a windfall of cash, like an inheritance, or they win the lottery, so what? Just give them the $50,000. You still have tons of money left, because people aren't filing bankruptcy to intentionally, screw over the creditors. They're doing it because they can't pay and they don't want to get garnished or lose their house, things like that. And so if they come into windfall, sure, take it. Yeah, I don't care, take it. Yep. We're good now.
Yep, good. And you said that we're on the uptick of the cycle, where we've been in good times, and now after COVID, we're kind of going on the uptick. Is that predominantly personal bankruptcy, or is it personal bankruptcy of businesses folding?
It's
like
both.
You just mentioned?
It's both. It's both, because, it's both. Because so most small businesses, and this is something that comes up a lot. I mean, it's a small business. It can be someone who has, a clothing retail store downtown. It can be an electrician. It can be a plumber. It can be someone who opened up a gym, for example, and they took out a bunch of debt right before in fall of 2019, or for example, these are all cases I've done. And then, for example, you sign on to a franchise for a barber, and you open up in fall of 2019. And then you put all this money in, and you personally guaranteed all the debt, and then they shut you down for a year and a half, right? But when you open up a business, unless you're like Coke or Amazon or whatever, you as the individual have to personally guarantee those business loans. And so that's a common misconception. Everyone says, well, I have an LLC or I have a corporation. It means I'm not liable. That's not how it works, I mean, it is how it works, but all the creditors know. So all the creditors have you sign a personal guarantee. So the business is liable, and then you individually are also liable. So when the business goes under and they can't collect on the business, well, they just look to the guarantors. It's like co-signing a lease for like your nephew or whatever. And then when he breaks the lease and disappears to wherever, I mean, they're calling you.
Yes.
It's the same kind of thing.
Yep. That's incredibly valuable information. Is there a way for someone, if they're opening a business, is there a way, and maybe this is more of a financial planning side or a business attorney side on the front side, for them to watch for that personal guarantor signature and say, I'm not going to do that? Or does the leverage extremely go towards the lender saying, man, you are going to do it if you want our money?
It's that. There's what you just said. I mean, occasionally you'll have a deal that's big enough where a lender, and it's almost always like with landlords, for example. And landlords are typically a huge expense for these businesses when they go under.
Yes.
Oftentimes, you can negotiate with landlords like a term for the personal guarantee. So if you're in a 5-year lease, for example, say, okay, listen, the first 24 months I'll do a guarantee, then it'll drop off. But by and large, it's just traditional banks and SBA loans. There's a personal guarantee on them, and that's just industry standard.
Yeah, no, that makes sense.
It does.
I just want anyone who's listening to this to have in their mind, what are my options? But I learned something a long time ago, and I don't know if it still holds true. At one time, I had heard that if not the number one of the top reasons for personal bankruptcy was medical expenses. And of those medical expenses that drove people into bankruptcy, many of them had health insurance, and it was still so high that it became problematic, and it took them under. Is that anything that you've seen as a practicing specialist in this area?
Yes, but it's bigger than that though, and okay. So what causes bankruptcy are financial shocks, and medical issues are almost always accompanied with a financial shock. They almost always have a financial shock right next to them because you get into a car wreck. You weren't
expecting this.
You get into a car wreck and you can't work for 3 months or whatever, right? Or 2 months, and that's a financial shock. And then so you can't work, and then you have a bunch of medical bills you can't pay because you can't work, kind of thing. And so it's usually that's usually what it is. It's the financial shock. It's not typically the medical bills, but that's not always the case though, because you're right. Like sometimes even if you've got insurance, just the copays are just so much.
Yeah.
But I will tell you though, you probably heard that prior to the Affordable Care Act, otherwise known as Obamacare, right? Mm-hmm. And so that was one of the main drivers for Obamacare. That was one of the things like the politicians would use. Obamacare will prevent bankruptcies and things like that. And I mean, anecdotally, I can tell you, I think it did, because you don't see as many medical bankruptcies, at least I don't think so, as you used to. Usually the medical bankruptcies now are typically financial shock related, or, you got the guy who has had health insurance for, 20 years, loses his job, has a new job lined up in 3 weeks. And if fate doesn't have it in those 3 weeks, slip and fall, you get into a car wreck or whatever, and you're uninsured during those 3 weeks. I mean, you go to the hospital, once for something like that, $200,000 later.
Yeah, it can get ugly
fast. And so you see that, honestly, I have a couple of those cases running right now.
When you talked earlier about state to state differences of Colorado kind of being generous in what they can allow you to keep and exemptions, that kind of thing, for you to practice individually, do you, as an attorney doing bankruptcy, have to have a bankruptcy or have an attorney license in every state? Or is there some, like immigration, for example, you have a law license and you can practice it anywhere in the country? How does it work for you?
Well, so that's a very insightful question. That's a very good question. I'll try not to go too long answering. I'll give you the short answer. The very short answer is no, you don't want to be licensed in every state. But you know what's funny about the exemptions is that you can't use the state you live in, the exemptions, unless you've lived here for 2 years continuously. I call that the OJ Simpson Rule because, OJ Simpson had his legal issues in California. Then he moves to Florida, and Florida has an unlimited homestead exemption. And so the guy lives in a $100 million house in Florida, but he owes those people hundreds of millions of dollars in California, right? And so what Congress did in 2005, they said, look, we don't want you to exemption shop. So we don't want you to go to a really generous state, file bankruptcy, then move back to where you were, keep all your stuff. And so the problem is if someone just moves here, just not for the intention of exemption planning, they move here and they haven't been here for 2 years, you have to look at the state where they came from and use those exemptions. And so, which is really tricky and difficult to do for an attorney who's not necessarily licensed in those states. It's kind of some weird ethical issues of like, okay, well, I'm not licensed in the state of Arizona. So you have to read these Arizona statutes. And so are you sort of practicing law in Arizona by using Arizona exemptions in a Colorado case? It's just a really sticky issue. I mean, to my knowledge, no one's really ever gotten in trouble for misinterpreting something. But I will tell you what, some of these exemption laws, and they're very specific. I usually just call a lawyer in Arizona. I mean, I get calls all the time from people that have moved from Colorado.
Yep.
It's just sort of a thing you do. You call a lawyer, you call around and say, hey, I think this is how it works. Can you just gut check me? Mm-hmm. And that's typically what I do.
And so if you had someone who called you, they listened to this show and they're going through a bankruptcy issue in Florida, could they call you and you represent them directly, or would that be the case where you'd call Florida licensed bankruptcy attorney?
Where are they living in your hypothetical? Are they living in Florida now?
In Florida, yeah. They just hear this and they're like, man, I'm struggling. This guy sounds like he knows a lot. He sounds compassionate, kind.
No. No, unfortunately, I couldn't help them out. I mean, because if you've been living... I can only do bankruptcies in Colorado and Wyoming. Got it. So Wyoming and Colorado is where I'm licensed to practice, and that's where I can do bankruptcy work. And so, but if they moved from Colorado to Florida and they have to use Colorado exemptions because they can't use Florida exemptions because they haven't been there long enough, then their lawyer is welcome to call me and talk about Colorado exemptions.
Got it. No, that makes total sense. As a bankruptcy attorney, can you share with us some of the main points that you walk through with the powers that be? So you're dealing with, I don't know, the state, individual creditors, whomever. What are just some of the day-to-day operational conversations or key points that you would hit for one of your clients?
So I think, and what you're saying is a perfectly reasonable assumption to make about how bankruptcy would work, but it doesn't really work. I think the way the assumptions you're making. So the way bankruptcy works is it's a pretty cut and dry. For most cases, it's a pretty cut and dry process. Is you meet with your lawyer, you give your lawyer a bunch of information. You need taxes, pay stubs, bills, like what do you own, things like that. And if you're under the means test, if you're under the means test, you qualify. You don't really have a lot. The lawyer just submits the stuff to the court. And you go to a hearing with the bankruptcy trustee, and it's an easy, quick, no asset case because everything falls within the exemptions. And then if nobody objects within 90 days of the bankruptcy being filed, you get your discharge and you call it a day.
Oh, wow.
It's fascinating. There's very rarely any sort of conversations with creditors saying, oh, well, I mean, we need to talk about this debt, we need to talk about what are the circumstances behind it. I mean, people feel like they need to justify why they filed. That is not how it works.
That's interesting. I would have not thought that. I would have thought that you had to kind of do battle with some of these people, but no.
Well, okay. Well, sometimes you do have to do battle with some of these people, but that is not the vast majority of cases. You're not doing battle with these people. I remember once I was listening to a Supreme Court case. I forget the issue, but it was on a bankruptcy issue. And one of the Supreme Court justices, I have no idea who it said, they looked at the bankruptcy docket and they said, oh my gosh, I mean, these bankruptcy judges get, thousands and thousands of cases assigned to them. Like that's just an insane amount of, how do these bankruptcy judges possibly do this? Because these Supreme Court judges, none of them are ever bankruptcy judges. They all just went through the regular system where they touched the case. Every case they were assigned to, they would touch at some point in time. But bankruptcy, I mean, the system is set up to where most of these judges, I mean, I don't know how these judges do it, but these cases come and go and you never see a judge, the vast majority of them.
Wow.
Yes.
Wow. That's amazing. I would have never thought that most of them don't go in front of a judge. Where do they get solved?
So they get vetted. I think vetted is probably the better term. So there's a program as part of the Department of Justice. It's called the U.S. Trustee Program, and I don't recall when this was implemented. Maybe in 1979 when they did the Bankruptcy Reform Act is probably when it really got its legs. But so there is a U.S. trustee appointed, and this person is an appointee in the Department of Justice. So then this U.S. trustee, they establish regions around the country. Then they appoint trustees for those various regions, and then that trustee will then have staff in that region. And so our region is Region 19. And I think we cover Colorado, Utah, Wyoming. I think that's it. But so that they're based in Denver. And so then that trustee has as a staff in the office, and then that trustee will then appoint individual trustees to oversee these bankruptcies. Okay. So that's how they're vetted. And so by and large, it's the bankruptcy process. It's Chapter 7s and 13s and 11s too are overseen by the U.S. Trustee Program. And so when you file bankruptcy, you don't meet with a judge, but you meet with a Chapter 7 trustee or the Chapter 13 trustee. And then that person is the boots on the ground. They make sure everything looks right. They protect they look for abuses. They make referrals up to the U.S. trustee, like criminal referrals, things like that. And they just kind of that. By and large, the Chapter 7 trustee and Chapter 13 trustees are probably the watchdogs of this. They're the first line of defense. They're the watchdogs of the system. And then if there's something up, they will report it up to the U.S. trustee.
I see. Wow. See, that's behind the veil stuff. None of us would have known
true.
that. That's super cool.
Well, I'm glad you think it's cool.
I do. And here's kind of a follow-up to that. Some people can do their own taxes. Some people need an accountant.
Yep.
If someone's going through something like this where they're going to do a bankruptcy, is it a thing where people like, oh, I'll just fill out my own forms and it goes to the trustee and they decide it? Or how would someone know, number one, is it possible to do it yourself, bankruptcy? And if it is, when should someone say, man, I'm over my head, I better consult with an attorney here?
Yeah, so that's a tough one for me. So I will tell you, so a lot of lawyers out there the answers would vary between lawyers. So a lot of lawyers say you're a moron if you do it by yourself. What's the old adage? Like, you represent yourself, you have a fool for a client.
Yeah,
is that what it is?
Yes, exactly.
There is a lot of value to that. There's a lot of wisdom to that statement. But here's the thing. To answer your specific question, you can absolutely do it by yourself. You can do it by yourself. And then you can even hire paralegals. That's not the right word. Like typists. I use the word, I use the term paralegal in the loosest sense possible, because some of these people that there's a subsection of the do-it-yourself bankruptcy. It's called bankruptcy petition preparers, and these are non-lawyers who are supposed to be just scriveners and just mere typists, and they will then do the forms for people, and they're typically pretty cheap. And I don't necessarily have a beef against these people, but it's a tricky area because it can be harmful to the public, because these BPPs, right? Mm-hmm. It's hit or miss. Yes. Some of these people, they harm their clients. They harm their clients, and these people, they're not sophisticated. They think it's like I'm going to a nurse practitioner instead of the doctor, right? Sometimes you can go to a nurse practitioner and get a prescription for something, right? Sometimes you need a doctor. Sometimes you need a specialist, right? But if you're equating kind of like a BPP to a nurse practitioner or like a real paralegal, that's a mistake that you're making. And these BPPs, in my experience, the good ones will disabuse the people of that notion and say, no, I'm not a lawyer. I just, you can get into trouble, but your case is probably simple, but I'll just type it up for you and do it right for you.
And then they would take that to an attorney. They would fill out the forms.
I don't know. I don't know if they bring it to an attorney. And most of the good ones are smart enough to say, oh, there's a problem here. I'm not allowed to talk to you about the problem. You need to go talk to a lawyer. And then the bad ones they just type it up. They don't care. And if they see a problem, I don't care. Not my job. I'm getting paid $200. I'll move on. Sometimes the bad ones will give legal advice to these people, and sometimes the legal advice is correct, but they're not lawyers. And when it's incorrect, you can't sue them, right, for malpractice, because they're not lawyers, kind of thing. You can sue them for other things, but then so you can do it yourself. You can do it with BPPs. So it's doable. You have to do your research, and you can definitely do it yourself. You don't need a BPP anymore. All these forms are online, and if you have the time and energy and the ability to read these forms, they try to make it. The clerk's office, they try to make it these questions they ask in these forms. They really do try to translate the legalese to layman's terms. So you can do it if you spend the time and energy doing it. The problem is, though, in my mind, it's a 50-50 shot. There's just so many nuances to bankruptcy. You could really be hurting yourself. And some of the biggest cases I've ever worked on are where people would file the cases on their own, because once you file, especially a Chapter 7, in for a penny, in for a pound, it's really hard to get out of a Chapter 7. So if you're going to be losing your house or your car, say, I don't want to do bankruptcy anymore. Well, that's sad. You're in. And so if you make a mistake, you're in, you're not getting out, and you might have some serious financial consequences because you didn't hire a lawyer. And the 99% of the time, lawyers would say, oh, no, don't do this. This is an issue. Because lawyers, they got a checklist. They see things. There's common things you see. Checklist, check.
Right.
you ask these questions. And so you can do it yourself. You can absolutely do it yourself. And if it's a super easy case, you can do it yourself. You can slide through. And if you're, you're smart enough, you work hard enough, you spend a lot of time learning how to do it, you can do it yourself. And I've seen some people do it themselves that do better work than lawyers, to be honest with you.
But those are lawyers that aren't specialists, right? Like you get your cousin Tommy, the divorce lawyer, coming rolling in to do a bankruptcy. I can imagine it's like us when nothing makes us crazier here at Ramos Law than when a non-PI attorney tries to take on a PI case without understanding. There's, like you said, so many nuances, so many little critical decisions that need and conversations that need to be had that it can affect their outcome in a huge way. I can't imagine that wouldn't be true in your case. Okay,
so unfortunately, the way bankruptcy works is that because the process I just described to you can be very systematic. Mm-hmm. I once had a buddy of mine, so I didn't coin this term, but it's very apt in the practice of bankruptcy law. I mean, that you can have JV lawyers practice bankruptcy. Most other areas of law, you got to be playing varsity, right? Because you're just going to get beat. But in bankruptcy, because it's so systematic, and a lot of your clients aren't very sophisticated. They don't know when you screw up, and you can kind of persuade them that you didn't screw up, it's someone else's fault, whatever. You can get, for lack of a better term, JV attorneys in there who aren't the best lawyers ever. And so I've seen individual clients do a better job than said JV attorneys. And there's a significant amount of those who practice bankruptcy law, which is, it is what it is.
It is what it is. Well, kind of winding the conversation down, I'm interested to know, someone goes through the process, they go through bankruptcy. Are there a series of steps that someone can or should do to start rebuilding their credit, rebuilding their financial health, besides just saying, hey, it's wiped away, we're good to go, I'm starting fresh? Is there any strategic things that people can or should look at to bring themselves back towards whatever we would call normal?
Yes, and so I would never hold myself out to be a credit lawyer or some sort of credit repair expert. I can only just speak to what I've seen and maybe what you read in publications from time to time. The best thing to do if you filed bankruptcy is you are going to want credit, is that you just go get a credit card, get a credit builder credit card, $500 balance. You might even just put $500 in the bank and secure it, the credit card to that, and you use it for gas every month, pay it off every month. And I can tell you, again, anecdotally from talking to some of my clients, within 2 years, you have 700 plus credit again, easy. Wow. In fact, most people, you get more offers for credit, especially cars, in the 6 months after you filed for bankruptcy, new credit after you filed for bankruptcy, just unsolicited mailers to your address. Then you got
very high rates, though.
Oh, high rates. Oh, yeah, high rates. You get more offers for credit than you got after everything you got before bankruptcy.
Wow.
Because you can't file again for 8 more years typically, and they can charge you higher interest rates. You're like the perfect credit risk. Like,
yes.
You have to pay us, and you're gonna pay us more.
Yes.
But wow. The best thing to do is just get a credit card, secure it to some money in the bank, pay it off every month, and you have outstanding credit again really fast.
Man, this has been a great conversation, Rob. I've enjoyed this so much. I think people watching or listening are going to get a lot from this, and hopefully if you guys have seen this, and whether you're going through financial pain or you know someone who is, please send them this episode, share it with them, let them start that process of knowing that it's okay, that there's options, that they are, it's not hopeless and it's not helpless. So that would be a really impressive gift that you would give to them. So as my last question to you, Rob, yes. Here's the last question. Is there one piece of advice that you've either been given or you've learned along the way that you would consider fundamental to who you are as a human being, not necessarily as a bankruptcy lawyer or a lawyer, but just something that says, man, this is the fabric of my being, that you'd be willing to share with us?
Well, you're putting me on the spot.
Because there's so many?
There's so many. Good pieces of advice out there. I'm a big fan of history, and I really wish I had like some really good Winston Churchill quote I could whip out, but I'd have nothing. I'm drawing a blank. I think what immediately came to mind, what a good piece of advice. I got to bring it back to basics. The golden rule, do unto others as you would have done unto you. Yes. And that's how I practice law. I'm never, you you're professional, you're firm, you're fair, you follow the rules, you don't be rude to anybody. I don't demean my employees. I expect not to be demeaned myself. And I think I just bring it back to basics, the golden rule.
I love that. Speaking of the golden rule, you have been golden today. If people wanted to reach out to you and learn more about how you might be able to help them, or learn more about your journey, or what it's like to be a bankruptcy attorney, what would be the best way for them to connect with you?
Yeah, I guess you just go to our website, cohenlawdenver.com or cohenlawwyoming.com.
COHEN.
That's right. Mm-hmm. And then, you can fill out the online form and request a consult, or you just give us a call. And I will say, if today's December 21st, 23, I mean, I'm so busy right now. It's incredible. I'm booking out like 3-4 weeks a month out right at this point in time, which is usually not the case. Most bankruptcy attorneys now are very, very busy because things are picking up.
The cyclical nature.
The cyclical nature.
Yeah. Well, I know that you've made an impact. You've made a difference today. Thank you so much. I mean, your time here, Rob, and is super valuable, and it's valuable to our listeners and our viewers. So thank you. I wish you the best. Sure. Obviously, an incredibly successful 2024 for you. And
well, you too.
You always have a friend here at Ramos Law.
Well, that's very thoughtful of you. Thank you.
Absolutely.